And you also see that there was an amended petition on February 9th, 1998, correct?
Yes, sir.
Would you agree that that more than 120 days passed between May 15th?
Objection calls for a legal conclusion.
No, it doesn't. It's a factual basis.
Hang on. Let him finish his question.
Thank you. Would you agree that between May 15th, 1995 and February 9th, 1998, more than 120 days passed?
The department renews its objection that calls for.
If you stipulate that more than 120 days transpired between the 3 years of these two documents being filed, Ms. McCarthy, will you stipulate to that?
Yes, Your Honor.
Okay, I appreciate that.
Moving on. That's a fact in the record.
Okay, thank you. And would Mr. McCarthy also stipulate that between 1995 and 1998, there's no record activity of the department showing good cause for failing to serve?
The department would stipulate that this document shows no record activity between 1995 and 1998. That's correct. Okay. Including no dismissal.
Okay. And would you also stipulate to the fact that between 1995 and 1998, there's no record activity showing an attempt at service?
Run this document now.
Okay, thank you. That'll work. Okay, so we also stipulate that according to the record on September 10th, 1998, an amended petition for support was filed.
Yes.
Okay. Will you also stipulate that between May 26th, 1999 and September 10th, 1998, there was no service of process?
To clarify, do you mean no attempt at service of process or no?
That wasn't my question.
Successful
no successful service of process.
There was no successful service of process. There were attempts at process.
Will you, I'll stipulate that there appears to be one. We don't have any proof of that, but there's an alias. Will we also stipulate that there is no record proof that there was ever a court hearing where the department asked for an extension of time to serve service of process?
There's nothing on the record about that. I can stipulate to that. I was not working for the department or the Attorney General's office when all of this occurred, so I don't have any personal knowledge as to what may have occurred otherwise at the time.
Will you stipulate that there was no evidentiary hearing to determine good cause for not serving from 1995 to 1990, February, from May 15, 1995 to May 26, 1999? Can we stipulate that there was never an evidentiary hearing to determine good cause for not serving process?
No, the department can't stipulate to that. I can stipulate that the record doesn't reflect any documents that would indicate that. But once again, I'm not aware of how the record was kept or how hearings were held back in the 1990s in this court. So it's possible that there were hearings that are not reflected on the court's record for one reason or another. So I can't stipulate that that definitely didn't happen. I can stipulate that the record doesn't reflect it.
Well, I'll stipulate I'll stipulate that the record doesn't show that it happened, and none ever took place as well. And by the way, you don't have to be working for the DOR or child support enforcement to just stipulate to the facts of the record, unless you're going to object to the record as being factually incorrect.
You've already stipulated to the record being admitted, so all of this is redundant.
But no, are you stipulating that the record is correct?
I'm stipulating that the record is the record that the court kept.
Okay, well, I guess Mr. Denton.
Once again, I was not practicing law when I was 10 years old, so I do not know what the practices of the court of Hillsborough County were at the time, as far as what was and was not reported on their record. So I cannot stipulate any further than that.
All that wasn't necessary. The question was, do you object? You didn't object to the record being presented, right? To the record at all, right?
The record has already been taken judicial notice of multiple
Okay.
times in this case,
Oh,
and there
okay.
has been no objection from the Department of Revenue.
Okay. Now,
For the purposes, the record can be taken judicial notice of.
okay, so when you go to 6/7/1999, do you stipulate that the record shows that a summons was allegedly returned, on 6/1/1999?
Yes, individual service on you on May 27th of 1999.
Okay, and do you stipulate that on 7/19/1999, the clerk issued a default judgment on that based on the record?
Well, it's not a default judgment, but a default was entered against you for failure to follow responsibility. Yes.
Okay.
It's not a default judgment. It's just it's not a judgment.
But it's a default, right?
It is a default. Yes.
Okay. All right. So I guess, Mr. Denton, what we have to do now is, because is it now that Mrs. Britt can now go back to testifying?
I'm leaving in 6 minutes, and so we can either finish this within the next 6 minutes or another day.
I'll object to you minimizing my right to fundamental due process.
You're hearing the
do?
schedule. Yeah, you didn't ask for a specific amount of time, and when you filed your motion, you were given a full hour. If you need more time, you need to let me know now. How much longer?
I don't think that's the issue, but the issue is
I've been here for quite a few hours.
you took the job, Mr. Denton, and
Right.
pursuant to 876.
I'm leaving in 5 minutes now.
That's
So
fine.
finish this today, or
Or what?
alternatively,
Or
you
what?
can take another day to finish the hearing.
Well,
What day?
we can do that as well. But first of all, you took an oath pursuant to 876 subsection 5 of the Florida statutes. And that oath was to support and defend the Constitution of Florida and the United States. And I could recite the whole thing down to 10, but you already know what happens when you don't do your job. So let's just go this. We'll go ahead and we'll continue this to a date that's convenient for everybody. But I want you to reconsider your recommendation.
Then file a motion.
Yes, I need you to reconsider that as well. And we'll come back and we'll
file a motion or do whatever you need to if the time still exists to do so.
Well,
Entered March 21st. So
the court can always review its own order. Just make the recommendation to Judge Smith to reconsider his rubber stamping of your that foolish recommendation. Didn't make any sense. Didn't even apply.
Okay, well, your commentary is needless.
Well, so is yours. So is yours, but I listened to it, right?
What day do you want to do this, and how long do you need? Monday or Tuesday, morning or afternoon?
Let's do it Monday morning, so we can sit here all day. But you have to read.
I'm going to give you I'm going to give you a specific amount of time. You must request the amount of time that you need.
Is that policy, or are you doing that just to me, Mr. Denton?
Sir, I'm telling you that I
asked you a specific question.
How about this? How much time total do you need? So I can just
3 hours. And 3 hours. And by the way, can I get this? Because once I vacate your recommendation, I'm supposed to be heard by a judge by rule. So are we going to come back and hear both of them?